This is a presentation by the Newfoundland and Labrador College of Dental Hygienists, which is your regulating body governed under the Council of Health Professionals. The Council has mandated that the college provide an information session explaining the policies regarding privacy, confidentiality, and consent. A copy of this policy can be found on our website. Confidentiality is a core ethic in our Code of Ethics. It is the duty to hold secret any information acquired in the professional relationship. Dental hygienists have the responsibility to demonstrate respect for the privacy of clients. In addition to ethical considerations, we are also to abide by federal, provincial, and territorial laws regarding the protection of personal health information. The goal of this presentation is to introduce members to the privacy standards of practice, the Privacy Resource Manual, and to also discuss the 2017 Privacy and Self-Assessment Tools. Privacy information in Newfoundland and Labrador is guided by legislation. The Personal Information and Protection and Electronic Documents Act became federal law on April 13, 2000. It relates to the data privacy and governs how private sector organizations collect, use, and disclose personal information in the course of commercial business. In addition, the Act contains various provisions to facilitate the use of electronic documents. The Access to Information and Protection of Privacy Act is provincial law for guiding Newfoundland and Labrador public sector. The Personal Health Information Act is a health sector specific privacy law that establishes rules that custodians of the personal health information must follow when collecting, using, and disclosing individuals' confidential personal information. FIA also sets out rights of the residents of the province regarding obtaining access and exercising control of their personal health information. FIA was established on April 1, 2011. The circle of care is an expression that includes the individuals and activities related to the care and treatment of a client. Thus, it covers the health care providers who deliver care and services for the primary therapeutic benefit of the client. It also covers related activities such as laboratory work or professional case consultation with other healthcare providers. There are 10 guiding principles within this policy, so we will take a couple of minutes to introduce them to you. As you can see here, they include accountability, identifying purpose, consent, limiting collection, limiting use, disclosure, retention, accuracy, safeguards, openness, individual access, and challenging compliance. Let's take a look at accountability. Accountability pertains to taking responsibility for your actions as well as your omissions when we consider our principles, standards, laws, and regulations. It includes the potential to self-evaluate and be evaluated. It involves practicing competently and accepting responsibility for behaviors and decisions in the professional context. So this means you must learn the rules, then test yourself to see how well you know them, then behave according to the rules. As a professional, we cannot say, "I did not know that." An organization, such as a dentist or a hygienist, is responsible for personal information under its control and shall designate an individual, called a custodian, who are accountable for the organization's compliance to the following principles. Policy and procedures must be available to you, the employee, the health professional within the circle of care. You are, as the health professional, you are accountable for the security of the information that you hold. You must ensure access is only granted by authorized individuals, and you must inform anyone who has access to the information of their responsibilities. Next, let's look at identifying purpose. We must ensure that individuals are provided information about the use to which their personal data will be applied. Most of our offices have consent forms. They should state the purpose of the collection of the information. Your consent form must also include potential use by the following: reporting infectious diseases, if your office is being evaluated, research, etc. This is secondary use, which is outside the purpose for individual care. Once the client is informed, they must give consent in order to proceed with assessment, treatment planning, and treatment. Consent should be given in writing, but can also be given verbally or implied in a case of an emergency situation where the client cannot give written consent. An individual still has the right to refuse consent or subsequently challenge the health professional's assumption of implied consent. Also, the client can revoke consent at any time, but it cannot be retroactive. Next is limiting collection. The primary purpose for the use, disclosure, and retention of personal identifiable information is to benefit the individual client who permits the information to be collected. We cannot use the client's personal health information for any purpose outside of the circle of care. The health professional do not need consent under these circumstances. Police with a warrant, a subpoena, an investigator, or a written request. Accuracy. What is our responsibilities for accuracy? At each appointment, it is our responsibility to ensure the personal information of the client is accurate. This includes address, telephone numbers, and medical history, the date of their last appointment, what their treatment was, etc. The health professional must take appropriate measures to ensure that personal identifiable information is not seen or overheard by other individuals who may be in the work setting. The owner or custodian must establish policies governing the retention, security, and destruction of personal health information to maintain client privacy. This protection should include physical, locked cabinets, technical, passwords and securities, and organizational, which is education for staff and availability of policy. The health professional must make readily available to clients and patients specific information about policies relating to the management of personal health information. You can have this posted to your website or have manuals available that can be read upon request. The Newfoundland and Labrador College of Dental Hygienists website has links that have resources to help you inform your clients. If you are feeling overwhelmed by the task of creating policies, there are great resources available. These are also available on our website. Clients have the right to access their information and to obtain a copy of that information. Confidentiality is owned to all clients regardless of age. The client owns their information. In the case of a mature minor, which is at 16 years of age, the consent of a child should be obtained prior to the release of personal information, even to a parent or guardian. If an individual is denied access to their file for review or correction, the client has the right to make a formal complaint under Section 65 in the FIA. A legal guardian, subsequent decision maker, or executor of an individual's estate can exercise the right of an individual. Challenging compliance. If you receive a complaint that you or your office has not complied with the Personal Health and Information Act, you must report the complaint to the Office of the Information and Privacy Commissioner, and complaints can also be made to the Registrar of the Newfoundland and Labrador Council of Health Professionals. The client owns their information. The custodian owns the documentation. The electronic or paper chart is the property of the health professional, but the information it contains is owned by the client. If you are taking part in a research project and you plan to use documentation from clients, you must refer to the Health Research and Ethics Authority. The resource manual is available on our website and includes guidelines for each of the following. For closing a practice, relocating, and referrals. There is a self-assessment tool that will help you to prepare your clinic. This will guide you through the operational guidelines and help you put in place safeguards to reduce the risk of a breach. There is a privacy breach checklist on the website within the privacy, confidentiality, and consent document. There are 4 steps to take in the incident of a breach. 1. Breach containment and preliminary assessment. Evaluate the risk associated with the breach. 3. Notification. And 4. Prevention of future breaches. There is also policy and guidelines on how to use social media. Let's take a minute to look at social media. What is our responsibilities around social media? You may be thinking, I don't have a practice or a professional website, so therefore this does not apply to me. Let's take a quick look at it from 2 perspectives, professional and personal. The policy states that all registered health professionals must continue to act according to professional and ethical standards while conducting any online activity. Registered health professionals are obligated to uphold public trust, and any inappropriate use of social media may be considered conduct deserving of sanction where a breach of practice standards can be demonstrated. It may be a good idea to limit befriending clients or patients, which can increase the risk of breaching confidentiality and misuse of personal information. It may be innocent enough, but it increases your risk for breach. In conclusion, the client has the right to privacy, and we are responsible to maintain that for them. Know the rules and follow them. You cannot use "I don't know" as an excuse for breach. You will be required to complete an assessment tool sometime in the future. The date is yet to be determined by the NLCDH, and they will give notice through email once the date is determined. If you have any questions, please contact the NLCDH at www.nlcdh.com. And there's a box which states contact us that you can forward your emails. Thank you for listening.